Welcome to ECHR's webinar. The repatriation of the jihadist foreign fighters has been a long-running dispute in Europe, particularly from the camps in Syria. We're now 3 years on after the collapse of the Islamic State's caliphate, and this issue is still burning away. Some EU countries have been more active in repatriating their citizens in these camps. Some, notably France, have been openly opposed to this. And they were recently chided for this by the European Court of Human Rights. So to talk us through these complexities and the various trade-offs involved, ECHR has put together an expert panel. We have Abigail Thorley, a researcher at the International Centre for Counter-Terrorism, or ICCT. We have Liam Duffy, an advisor to the Counter-Extremism Project in Britain. We have Sharon Whale, an associate professor of international law at the American University of Paris, among other things, and Sophia Koller, a senior research analyst at the Counter-Extremism Project in Germany. So welcome to you all, and if I can go to Abigail for the first round.
Yes, thank you. Well, it's good to be here. Basically, prior to the recent ECHR decision, there's been a lot of discussion basically about repatriation. The poor situation in camps is something that's completely not new to the media or discussions of scholars and practitioners alike. Examples of lack of sanitation, exposure to violence, and lack of food and healthcare have all been extensively documented in the recent years. At the current point, there currently stands somewhat around 7,300 children from across 60 different countries that are detained in the Al-Hol and Rosh camps in the northeast Syrian region, most of whom are actually under the age of 10. It is also no secret that many of the human rights are being violated there. While some countries have been repatriating women and children for some time, namely Kazakhstan, Uzbekistan, Kosovo, Albania, and also more recently Kyrgyzstan, there's been a bunch of European countries that have also started to repatriate more actively from camps. For example, Germany and Denmark have jointly repatriated 37 children and 11 women from camps. The Netherlands has repatriated 5 women and 11 children, with more likely to be repatriated soon. Belgium has brought back 16 children, 6 women, Sweden 20 children, 10 women, and France 35 children and 16 women from the Roj camp, marking the first time French adults have been repatriated from Syria. Prior to the recent ECHR decision, the debate on the extraterritorial jurisdiction of human rights has been discussed, although there hasn't really been a conclusion to date. Regarding the law, states have a general obligation to respect the human rights of those within their jurisdiction, which, as commonly interpreted, means on their territory. However, there are exceptions to this, whereby a state exercises jurisdiction abroad through effective control of either the territory or the power over an individual abroad. There are many factors that go into determining effective territorial or personal control, of which I won't get all into today. But it is important to note that there is a distinction between a substantive violation of a human right and the procedural aspect of determining whether a state has the jurisdiction and thus the human rights obligations attributed to them. When jurisdiction has been established, then it is the state that has a positive obligation to respect and protect the human rights. However, the more recent decision is over the interpretation that when states exercise effective control over the activities that cause damage and consequent human rights violations, it does have jurisdiction. If we now focus this debate in the context of European countries repatriating from northeast Syria, it has been well confirmed by various bodies, including the Committee on the Rights of the Child, that the rights of children within these camps have been violated. Thus, given the large portrayal of the situation, no state could claim not to know about the poor conditions these people face. The main question then is whether the state's jurisdiction meets the requirement of effective control in these cases, and which factors should be taken into account to make these assessments. In the opinion of the committee, the admissibility of the situation arises from the nationality link of these children detained in the camps, the information the state has on those children, the relationship the state has to Syrian authorities, and the capacity and power of the state to protect the rights of these children through taking measures to repatriate them or provide other consular measures. Although this idea of basing jurisdiction on a nationality link has faced backlash, it is also seen in the ECHR case that the argument portrayed by others is that it is not meant for widespread application, but for specific cases of children identified in camps. Looking particularly at the situation with France, the committee noted the capacity or the capability of France to protect the rights of the children through due diligence, as France has recognized the poor conditions in the camps and has already taken action to repatriate other children and mothers, which shows that they do have a power and authority over these individuals. Other actors have also been seen to intervene in the recent proceedings of the ECHR, including the European Commissioner on Human Rights, the UN Special Rapporteurs, along with several NGOs and experts. These bodies have all overwhelmingly supported the opinion that France has an obligation to repatriate their nationals, given they have provided their ability to repatriate other nationals from the area in question. Additionally, they concurred with the idea that France has a positive obligation to protect the human rights of its nationals in the camps, in line with the committee's view on the matter. If we now look towards this rights-based approach, it is still very much contested, and many were looking towards the recent decision to take a strong standpoint. However, in my opinion, the decision appears to leave little to celebrate, and it may even be questioned whether the court has decided to sit on the fence regarding the matter. In its final judgment, the court unequivocally denies the argument that the French nationality of the women and children of the case provides a sufficient link with the state in order to establish the jurisdictional link between them that would require the state to comply with positive obligations regarding them. Therefore, it also decides that France's operational capacity to repatriate does not suffice to constitute a basis for an extraterritorial jurisdictional link. In analyzing Article 3, Paragraph 2 of Protocol Number 4, which is one of the more prevalent ones within this case, it's also namely the right to enter the territory of a state of which you are national. The court analyzed whether an obligation to repatriate could be derived from this article. Although it made sure to emphasize the occasional humanitarian repatriation of minors in difficult situations did not create an obligation, others could basically say that they didn't want to make sure that there was a chilling effect on state operations for fears that humanitarian action might become an obligation in the future. As a result, the court denied that there is a general right to repatriate within this case. Although despite not guaranteeing this general right, the court did acknowledge that obligations stemming from this article, including positive obligations to ensure nationals the right to enter national territory, is practical and effective. In determining whether a state has failed to fulfill its positive obligations, the court noted that where exceptional circumstances exist, there would be a positive obligation of the state to protect against arbitrariness. In deciding whether this was the case in the particular recent case, the court considered several factors, including that the camps were being controlled by the SDF in a somewhat legal vacuum, only Common Article 3 and the 4 Geneva Conventions of the International Humanitarian Law were being applied. The general conditions of the camps were incompatible with applicable IHL standards. There was no tribunal. The Kurdish authorities had repeatedly called on states to repatriate their nationals. A number of international and regional organizations had done the same, and France had officially stated that French minors in Iraq and Syria were entitled to protection and could be taken into its care and repatriated. In this case, there were exceptional circumstances, and given such, the French authorities do have a positive obligation to ensure that any decision-making process concerning requests for repatriation are safeguarded against arbitrariness. The court proposed that in order to examine requests for repatriation, an individual examination conducted by an independent body, separate from the executive authorities of the state, must occur. However, this body does not have to be a judicial authority. The violation of Article 3, Paragraph 2 of Protocol Number 4 was found in this case because there was no explicit explanation given of the grounds upon which the repatriation requests were denied. Instead, the applicants merely received a general policy document which outlined the French government's policy. While this case does bring some hope for those detained in camps, as requests will now have to be reviewed in a non-arbitrary manner, the case does not follow the progressive opinions of the Committee on the Rights of the Child, alongside the special rapporteurs and NGOs, towards a rights-based approach and general rights repatriation. And it presents the question of what the future of these repatriations will be in light of the decision against the right to repatriation. As we look at the current status of repatriation, most frequently states have cited domestic security risks supposedly posed by returnees as a justification not to repatriate. There's also been justifications, including the argument that justice is better served in Iraq or Syria, as witnesses and evidence is more easily found there. The narrative that traveling abroad to fight in Syria and Iraq, often in breach of national laws, is voluntary in nature, and regarding children, that it is inappropriate to separate the child from their parents, so neither will be repatriated. If we look at indicative ranges of the remaining children in camps, currently the Netherlands has approximately 60 children remaining, Belgium between 12 to 17, Finland between 6 to 8, Sweden 25 to 30, and France between 150 to 170 children. It is also only recently that most states have changed their policies to begin repatriating children from conflict zones. And so far, the policies being implemented mostly only allow for decision-making regarding repatriation to be conducted on a case-by-case basis. The criteria of which such determinations are made is also not typically made publicly aware. The stigmatization of these individuals when returning is also highly prevalent, hence the need to look at the practices of other repatriating countries. Central Asian countries, Kosovo and Albania all have experience of repatriating from a much earlier point, meaning that they have also been given the opportunity to gain some insights on how best to repatriate and how to manage child returnees. Through repatriation, a lot of these countries have often referred to the individuals that left to fight for ISIS as citizens rather than foreign terrorist fighters, which already greatly impacts how these individuals are perceived. This also contributes to a process of humanizing returnees and facilitating their reintegration into society. Going forward, it's imperative that repatriating countries should ensure that rehabilitation and reintegration policies and measures address all of the complex needs of child returnees, from support for trauma experience to education and supporting identity in the short, medium, and long term. In respect of children, they should be treated as victims and have the best interests of the child at the forefront, with focus being placed on health, education, the child's view, identity, the preservation of family ties, development, and their protection and safety and care. Children are not homogeneous, and therefore they do need tailored approaches to ensure that their best interests are met on a case-by-case basis. Given the multitude of actors involved in this process, processes would benefit from there being a single contact person assigned to a child and their family as a way of ensuring that they understand the roles and responsibilities of each action, and so their needs can be tailored into action plans. And for now, we will have to see how things develop in the light of the recent situation, but I'm very interested to see how everyone else interprets the recent decision.
Thank you very much. A great start. Can I go over to Liam for the second round?
Sure. Yeah. Thanks, Carl. Thanks everyone for having me. I'm not necessarily. I think I've explained this to you, Carl. So I think hope this is okay. But I'm not necessarily going to talk about the ruling or kind of the ins and outs of policies and approaches, but more talk about the cultural discourse around foreign fighters or travelers, Islamic State migrants, whatever we want to call them, and returnees. So
Absolutely.
I guess in order to do that, I'll split it into 3 parts. So like before, during, and after. So I think in order to really assess the plight and the future of those who travel to Islamic State's territory at the moment, we need to go back a little bit and go to before they traveled. Like, where did they come from? What do we know about them? How this phenomenon happened? And I'm only going to really talk about this from the UK perspective, because that's obviously what I'm most familiar with. I know some pretty valiant efforts have taken place in some countries like France and Belgium to understand the foreign fighter phenomenon, but I think it's been a pretty paltry effort in the United Kingdom to really understand how this phenomenon happened. We're talking about 900 at least British citizens or British residents, people born, raised, grew up and educated in the United Kingdom in a kind of liberal, tolerant democracy, choosing with not calling them a terrorist group doesn't really do it justice. They were genuinely genocidal force in the Middle East at the time. So, there's been not a whole lot of effort since it happened, when there were obviously a lot of books published at the time, but not a lot of kind of historical work into understanding that phenomenon and that contradiction that I just described. So I think if we go back to the before part, I think it was kind of anybody who's listened to me talk about this won't be new to them, but I think it was kind of divided into a few dominant discourses on IS or ISIS radicalization, and there were kind of the socio-economic explanations, the ones that said that this was a question of marginalization or socio-economic marginalization, alienation, a kind of backlash against society and things like that. There was what might be called the kind of what sprung up the CVE online radicalization industry, this idea that this was all happening online and there was something unique about Islamic State's propaganda that was attracting large numbers of Europeans and large numbers of Brits. And then there was the discourse that was coming out of certain sections of the right and the far right, which was that this was about this was a fundamental problem of Islam and Muslims that was the issue. When you actually, well, again, I'm referring to some of the work that's happened in France and Belgium to understand this problem. When you actually look at geographial mapping of where foreign fighters came from, those kind of dominant discourses or dominant explanations really take a bit of a hit. Because if it was either an online phenomenon or it was a socio-economic explanation, we would obviously see quite big geographical distribution, but we actually don't see that. We see over 90% of ISIS foreign fighters. Again, foreign fighters is a bit misleading because obviously not everybody was a fighter for the group, but recruits or travelers, over 90% came from just 5 or 6 European countries. So overwhelmingly, most European countries weren't actually affected by this. And then within those 5 or 6 countries, you only need half a dozen to a dozen towns, locales, neighborhoods that were really overwhelmingly affected by foreign fighter departures. And then even within those towns, sometimes it's the same postcode, sometimes it's the same apartment complex, sometimes it's the same, street, the same family. So, this massive geographical clustering that we see really, again, puts a dent in the online and socioeconomic explanations. But it also, if you also look at the areas that weren't affected, the explanation that came from, like I said, from sections of the right and the far right kind of falls down as well. So there were some population centres which were obviously have high Muslim populations, like Marseille, like Glasgow, like Bradford, that were really not affected by foreign fighter departures. So again, if this was a problem of just Muslim populations or anything like that, then obviously you would expect to see those areas affected. Obviously, though, a city like Marseille or Glasgow or Bradford has all sorts of socioeconomic challenges and obviously has the internet as well. So I think a bit more introspection about how this happened and why we see that kind of thing. Obviously, it seems that the key variable is the presence of veterans of other conflicts like Algeria, like Bosnia, like Afghanistan, other jihadist theaters, which is important for the discussion on repatriation. Then if we come to the during part, and this is linked to my point about there not being a whole lot of historical study about what's been going on here and people kind of looking at future threats and things like that, there's kind of a bit of a black hole in our understanding. We don't really know what people got up to for 4 or 5 years while they were in Islamic State. There's kind of this period of radicalization and departure, and then there's this we now know that they're in Al-Hol or they're in makeshift prisons in northern Syria, and we really need to do a lot more effort to fill in the blanks there. We do have a little bit of information, like in some of the cases that have taken place in Germany that I'm sure Sophia will talk about, with especially women who've been found guilty of involvement in genocide against Yazidis. And my own research, which polled a group of Yazidi survivors of the genocide, said that 50% of those survivors had contact with Westerners while they were in captivity. We've got other documents like USB leaks of Dutch foreign fighters, which showed that the overwhelming majority of them signed up to be frontline fighters or even suicide bombers. So by not having that information and not really doing enough groundwork to fill in that gulf of understanding of what actually happened in that period during the caliphate, we're kind of conceding the narrative a little bit and allowing some stranded foreign fighters now to claim that they were, played a bit part in the caliphate, or they were cooks or engineers, or they were, again, repeating some of the tropes and mythology that I mentioned in my first comments about them being online radicalized or manipulated. And And actually, just to come back to that, this idea that this was like some kind of youth rebellion and this massive, overwhelming focus on young people who joined ISIS, and in my own country, focus on people like Shamima Begum, really skews the understanding, especially when you look at the average age of departees was 24, 25 in most countries. Most of them have been part of activist networks, Salafi activist networks, for several months or even several years before they departed for the caliphate. So I think if I can get one thing across, it's that not that ISIS was doing the radicalizing, it was that ISIS was actually, what happened was the caliphate revealed the extent to which European Salafi jihadism had grown in the interim kind of 10 years since the previous flurry that we saw. So we saw attacks and people departing to Iraq to fight in the insurgency there in 2003 to 2005. And then we had a long dormant period. And then all of a sudden, thousands of people leave, and a number of really horrific attacks in between 2014 to 2017. You know, and there was this idea that this all happened overnight, and this was a result of ISIS's unique propaganda and unique recruiting power. Obviously, I completely reject that explanation. And what happened is, I think, is what is happening now is that we're ignoring the movement in the lull. This is a movement of ebbs and flows and lulls and highs, and we ignored the fact that this movement had multiplied and grown exponentially in between 2004, 2005 and 2014-15. And ISIS kind of ripped the lid off that and showed us exactly how big this movement was. Some of the networks in some cities, Toulouse, Birmingham, in parts of Gothenburg, the networks had gone from 3 to 4 people to 300 to 400 people in the space of that 10 years. So really exponential growth. And now when we talk about after, as I mentioned, we now know that a large number of people are stranded in Al-Hol or they're in makeshift prisons. There's also a large number of people who have returned, but there's also a large number of people that we're actually completely unaccounted for. We have estimates on the number of deaths, but there's still numbers of fighters that we actually don't know anything about. And we saw Abdel Barry, British wannabe rapper, at one point turn up and get arrested in Spain. We don't know how many other people are out there like that as well. And I think this debate, if we can carry on talking about after and what happens to the foreign fighters, the debate is really a bit, not surprisingly, polarized, a bit binary and a bit simplistic. And I think you only need to look at the case of 2 of Britain's most famous foreign fighters, so Alexander Cotti and Al-Shafi al-Sheikh, who were infamously members of the Beatles, who were given life sentences and much more in the United States recently. Actually, if you go back and look at documentation from the Crown Prosecution Service in the United Kingdom, at the time when there was a big to and fro between the United States and the UK back in 2019, 2020, over their fate, the Crown Prosecution Service determines that there was insufficient evidence to prosecute these guys, and that they basically had no confidence of securing a conviction against them if they were to return to the United Kingdom. And let's think about that for a moment. This is Alexander Cotti and Al-Shafi al-Sheikh. They are 2 members of the Beatles, which was, we know, a kidnap, torture, and execution cell. We have mountains of evidence about their involvement in ISIS. We have eyewitnesses. We have people, survivors of their captivity, and yet our laws and our court and our judicial process still determined that there wasn't enough grounds to be confident of securing a conviction. So the United Kingdom basically had to outsource justice to the United States. So obviously, not only is this like a searing indictment of our legal system's inability to respond to the unique challenge of global jihadism, it also shows that, just saying broad brush statements like, we should repatriate Britain's foreign fighters and they should face justice at home. They're our responsibility, so they should be our problem. Well, actually, we need to probably accept that if we repatriate people, they're going to walk free to the UK. I don't know, I can't talk for other countries, but they're probably going to walk free. If we accept that, and I'm not necessarily talking about among kind of experts and terrorism scholars here who probably know this, but in the media, that dominant discourse tends to be either, these people are monsters and should be left there, or they should return home to face justice. I think it's important to stress, actually, not lie about this and not obscure the truth. If they do come home, they're then probably not going to face justice. If we accept that and we still think that they probably should be repatriated, then fine, but we shouldn't obscure the realities of this. And I think, speaking of the extremism field and terrorism academia broadly conceived, it's kind of like dare I say it, and this is where I'm just playing devil's advocate, Kyle, and we discussed this. I think to avoid everybody kind of singing from the same hymn sheet, I'm going to play devil's advocate here. But I think there's a bit of a, it's kind of the fashionable thing to just say, you know, we should repatriate foreign fighters, and this is the most obvious choice in the world. But actually, you know, the consequences of those decisions are not on our shoulders in the same way that they are on policymakers and elected officials. We're not privy to the same intelligence that policymakers and elected officials are. We're not going to be held to the same standards by the electorate if something went wrong, if there was ever an attack committed by one of these people who were repatriated as well. So, and I think, as I said, we should be honest about, in the United Kingdom, again, I don't know about the other cases, but in the UK, repatriation means that a large number of returnees will go free. So I think this is a much more complicated decision than the binary kind of discourses in the media and in our own fields would have you think. And I think we just, like I said, need to be honest about this. And my own position is that they should be repatriated, but I say that in the full knowledge that they probably will walk free. And that is a distressing thought, especially given what I said about the growth of jihadist extremism in Europe in the interim 10 years between Iraq 2003 and then the caliphate, or the interim decade or so. We know the influence that returnees had. And I think the other final thing that I would link to that is we're potentially making a really grave mistake in not only the framing of some of these people as victims of manipulation and victims of online radicalization, but actually a borderline or quasi like celebritization of some of these people, as we've seen in certain countries. And you know, the idea that you can just go and join a group which is committing genocide against minorities in the Middle East and then come back and, you know, tell your story on daytime TV or have a book deal or have a podcast, I think is really kind of morally unserious. And we've seen similar things happen in the past with, for instance, Guantanamo inmates or people who were detained in Iraq. There's kind of a logical failing where we're like, you know, Guantanamo is bad or detention in Iraq is bad, therefore these people are good. And what's happened, the people have come back to a bit of a fanfare and then gone straight back to being involved in terrorism. Most obvious cases of Osama Attar in Belgium, who was the subject of a big public campaign, went straight back to Islamic State when he got released, when he got repatriated to Belgium, and was kind of the mastermind behind the Paris attacks and the Brussels airport bombing. So I think, you know, we can advocate for repatriation without celebritizing and without whitewashing these people of their crimes as well. So again, not getting into the nitty-gritty of the policy issues and legal issues and things like that, but I think just a plea to have a bit more of a serious and honest debate and discourse on this. That's it for me.
Gives us a lot to come back to. Thanks for that, Liam. Sharon, if I can go to you for the next round. I think you're on mute.
Yes, it's
Thank
good.
you.
I'm here. Thank you. Yes, so thank you for inviting me. So I was also asked to discuss the case, so I don't want to have any kind of repetition with what have been said. Maybe I can just react to what Liam has just said, that you know, at least in France, the discussion is not whether we take seriously what they did or not, because I don't think someone is not taking it seriously here. And quite the contrary, when people will be get repatriated, and of course, when we speak about foreign fighters, so I'm not speaking about kids who are 2, 3, 4, 5 years old. I don't know how old they are. So of course, when the adults are repatriated because they went there to join what in France is seen as a terrorist group, meaning one of the groups that are on the list, like, you know, the ISIS or the Jabhat al-Nusra, etc. So that they're immediately here in France committing a criminal offense that has an extraterritorial application. So we have absolutely no problem from the minute that they arrive here to start a criminal investigation, even though most of these people are already under arrest warrant. So once they arrive here, they're immediately arrested. They are put under arrest under the end of criminal proceeding, because for this special infraction, which is joining a group with the terror purpose or something like this. I don't know how to translate it really in a good way, but once you join a group, so this is the offense. You don't necessarily have to yourself contribute to anything, nor that anything has been actually done, but it's simply the fact that you joined a group is the criminal offense, and you can be prosecuted here until 20 years or even 30. You know, the legal framework is taking very seriously the people that went there, and whoever comes back is going immediately to persecution and for many years. So there is another issue about bringing or not bringing those people, and you know, it could be a kind of a revenge, or a kind of you decided to make another alliance, so now I'm not, you know, you are not part of our community anymore, and we are not going to take care of you. I mean, I think this is what is going on behind the argumentation, because otherwise, you know, we could think that there is no special danger from a security perspective to bring those people. The contrary is more true, because we know that the people that are there can get more easily free and get more easily new connection there than they are here when they are put under maybe surveillance or control or everything. Not that I'm in favor of this, I'm just, you know, looking also from a security perspective. And here you have investigative judges of the counterterrorism unit that were saying this. It's much more secure to have them here than to have them there. Okay, so this is it. Now, so what is the justification not to bring back kids? So, you know, the justification, oh, they will be completely emotionally complicated. Those are ticking bomb, even people were saying, and you know, things like this. So of course, kids are kids, and then with the necessary care, of course, it would demand a certain kind of care, but then I think that they could fairly be integrated again in society. And if they come back with the mother, so, you know, and the mother is going to be persecuted, then there are solutions to bring to the bigger family. This is usually what is going on, or simply through special units that will take care. Now, if I go back to the case, so I like tend to agree with the first speaker that you know, it's not like big news in the realm of human rights law, but nevertheless, I think it's an interesting decision. So first, what we don't have here, so we don't have here the idea of, you know, if a state is not doing something, then it could be responsible for the violation. And I think that this is what the lawyers were trying to argue. They were saying, listen, by the fact that France is not giving back those kids and the family and the mothers, it basically allows their being tortured. Because or inhumanly treated. So France has the possibility to repatriate them. The Kurdish is asking them to do it. France is not doing it. And therefore, there is a violation of Article 3, the prohibition of torture. This is what the lawyers were saying. And this is what the court did not accept. And of course, you know, so the first speaker spoke about jurisdiction. And of course, this is always the first question, until where state has an obligation to protect rights. So all the time we go, you know, as far as we go with the extraterritoriality, also there's all the time pushbacks, you know, so it's like the refugee in the Mediterranean, right? So the fact that it's not the European state that are torturing them, but they do agreement with the Libyan authority, so they make sure that the Libyan will take the people from the Mediterranean and then they will get torture. Yeah, but Europe is doing nothing, right? So it's always about this, you know, how far you bring your jurisdiction and you externalize responsibility. So here the lawyer was saying, listen, you don't stop externalizing responsibility. Okay, you may have the responsibility because you have the possibility, and this is what the Committee for the Rights of the Child accepted, and this is what the court did not accept it. And by the way, it's not only the court, because you have many states that gave their submission. So you have the Belgium, the British, the Danish, the Dutch, Norwegian, Spanish, and Swedish. All together, they were saying that there is no jurisdiction, and voila. So in this sense, the court agreed on this, and it couldn't go as far as claiming, because these French people and France had the possibility to repatriate them. They couldn't find it a violation of the torture and human treatment. However, there were two arguments. So one argument of the lawyer was violation of torture, and the second was violation of an article that was the first time that was dealt with in the European context, in the European Court, which was Article 3.2 of Protocol 4, and which says no one shall be deprived of the right to enter the territory of the state of which is national. So here we don't have the problem of extraterritoriality, because of course, if someone is outside and we cannot deprive him for getting in, there is already an extraterritorial component, right? Unlike, let's say, the torture article. So around this question, I think this could open, you know, the door to have jurisdiction. And it was quite an interesting argument. I mean, it was an interesting thing of the lawyer to bring this article to say, you know, this article by definition is extraterritorial, because you need to be outside in order to get in. Okay, so the court is saying it's not enough that they are French, so the nationality by itself do not allow for jurisdiction, but we have different, you know, special cases here, and the first speaker, she mentioned all of them, so I will not tell them again, but the fact that the Kurdish want them to go, that they cannot leave themselves the camp, right, unless someone will help them to do it. So in a way, this right cannot be effective unless, in this case, France will help them. Okay, so, but at the same time, the court is saying, but you know, so we recognize the jurisdiction of this right, but we don't recognize automatically that France is obliged to repatriate. So there is not this correlation with the obligation of repatriation. This is really from another regime. It's more it's from another regime. But here in this particular article, they said that they may have positive obligation in order to make effective this right. So what they are saying, the French, is, listen, you know what, you decide. We court, we don't tell you what to do. So they give it back to the government, to let's say the state. But they are sending very strong signal. They are saying, listen, the entire decision process here was bad. It was not transparent. This is not how democratic society function, especially when we are dealing with such suffering of your kids, right? He was saying this, that in this democratic context, it's not to be done. So basically, they are saying the court, you know what, you do again, you reconsider. Now, whatever you decide, you need to have a certain kind of an appeal that will be more independent, and where you will explain really why you don't want to do it. And then also the person or the family of the applicant could also expose their interest. So I think it's true that, you know, it's not a big sensation in what the court is obliging to do, but in a way is sending very strong signals to the court what should be done. So in my opinion, this could really, so, you know, there are two possibilities now. Or we are going to, or France will reassess its policy simply. So the state itself will reassess its policy and will decide to bring back those children. Otherwise, they will need to create an independent body, and then, you know, and then it will take the time it will take in order to make the appeals. But, you know, time is passing, and those kids, they were 1 year, now they're already 4 years. So, you know, the time it's quite pressing, at least for these kids. Voila, so this is what I wanted to know. So despite the fact that this is not huge news, I think that it could have nevertheless, you know, a strong impact on the internal decision making. Thank you.
Thank you very much. If we can go to Sophia for the last round.
Yes, thank you so much. And I have actually prepared a couple of slides. So if you could just authorize me sharing them.
Yes. Sorry. Whenever they ask me to do technology things, it'll just quite wrong. Sophia,
I can just start with the first phrases while you figure it out. So thank you so much for the previous speakers. I was kind of hoping that the other speakers would touch on the more legal issues and on discourse. So that's all been very, very well covered already. And in my presentation, I will actually focus on a German perspective, so on a national perspective when it comes to repatriation from northeastern Syria. So we heard it before, Germany is among the countries that have in Europe repatriated both minors and adults, and that has been happening 5 times since 2019. You don't have to remember all the numbers, so I think the most important point here to keep in mind is that since 2019 until today, actually, September, Germany has repatriated 69 minors and 22 adults. And there are several aspects that I would like to highlight in Germany's approach to repatriation, because I think it's quite interesting given how this has also evolved. So one aspect is that as many other countries, when it became clear that the caliphate was crumbling, that there are more and more people stranding in the Kurdish administered camps, there was the question of what to do with European nationals, especially what to do with minors. And for Germany, there were 2 factors that contributed to the decision to repatriate, who were at least reportedly kind of happening at the same time. So one aspect is that there were indeed discussions on the humanitarian need of minors, especially very young children or orphans, and also sick children. So there was kind of an increased awareness that some of these minors would have to be repatriated rather sooner than later. And at the same time, there were several relatives of families in the camps who went to German courts and have in some cases successfully forced the German government to repatriate. That was mostly the case in camps al-Hol. We have heard of the horrible conditions that persist. In other cases, the families lost their cases. That has mostly been the case when it comes to the Roj camp, because it's reported that conditions are better there, so there is no immediate need to repatriation. So these are kind of the 2 aspects that, yes, Foreign Office has been repatriating out of humanitarian needs when it comes to sick children and orphans, but there were also court decisions forcing the German government to actually move on the repatriation. And then what Germany has done is it has many times cooperated with other states such as Finland to ensure these repatriations, which has not always been that easy, but it is one approach instead of France, who to my knowledge has repatriated on its own, but there's also different presence of countries in the region. Another aspect I would like to stress in the German case is that some of the courts have also stressed that children cannot be separated from their mothers when they're repatriated. So what has actually been happening is that first repatriations were of children alone, so as I said, orphans mostly, but then the next repatriations were minors together with their mothers, so which means that adult women were not repatriated in their let's say own capacity, but actually in their role as a mother to the the child, which cannot be repatriated on its own. And I think this is an important aspect because it allowed Germany to prosecute also female fighters or female IS members as a like a side effect, but not as a decision on its own. And then finally, also the repatriations are organized in such a way that these people, so minors and their mothers, arrive at Frankfurt Airport, and then the federal responsibility ends, and it's the German states who take over, depending on where the person came from, where they will be charged, and so on. So usually now female returnees are put in pretrial detention. Against many there are arrest warrants, and the children are usually taken over either by their own family or a foster family. That depends on the case actually. So I just wanted to touch briefly on the implications of the ECHR decision for Germany, and in my opinion, it's not major in the sense that Germany is one of the countries who has been relatively active in repatriation. There are relatively few children and mothers left in the camps, at least those of German nationality. So depending on the sources, there's only a handful where there is German nationality established. And from what I hear from government sources is that it is expected that the remaining German nationals, so minors and women in the camps, will be repatriated this year, or at least in the coming months. Of course, this is like not a promise. It depends on many factors, but this is kind of the policy that has been decided. So I would say that Germany is kind of in a quite comfortable position of saying, well, we're already doing the right thing right now. So what I would like to focus on is actually what are the real challenges then if Germany is doing such a great job already. So I would say there are three aspects to it. First of all, and we touched about that, what about people who do not want to be repatriated? So either people who have fled from the camps and are now kind of off the radar in northwestern Syria. This also includes women and children. There are also people who have no German nationality, but kind of a connection to Germany. So they, for example, have been residents or they left from Germany, but they cannot claim this kind of protection to be repatriated to Germany. So there's several potential security, but also humanitarian risks coming from that situation. Second, also, I think one of the biggest challenges for the years to come is actually what to do with German male fighters detained in Syria and also other foreign fighters detained in Syria, because there's kind of the next topic. And then finally, once they return, of course, also mid to long term will be their prosecution, rehabilitation, and reintegration. And that's why for the second part, I would like to briefly touch on how Germany has been prosecuting and has been working on rehabilitation and integration of returnees from Syria. First, when we look at prosecution of returnees, I have recently published something on the prosecution of female returnees. So more details can be found in that paper, but just some aspects that I find important. So in Germany, the main offense used for prosecuting both male and female returnees is membership in or support of a foreign terrorist organization, which is punishable with up to 10 years. These are slightly different sentences than we see in France. So that's one of the issues, that we have relatively short sentences when compared to other countries. And then in many cases, it's also used the war weapons controller, because this is something that you can also find evidence on. Other offenses that have been used are offenses against children, so child endangerment, child abduction, but also interestingly, Germany has been quite active in also charging and convicting returnees under international criminal law. So this included war crimes, crimes against humanity, and also aiding and abetting genocide. So I think this is a very, very positive development to not only prosecute returnees for terrorism-related offenses, but also bring in accountability for crimes committed against the Yazidi community. So I think this is something that should be explored further down the road. Finally, what I find interesting in the discussion is also that there is a rather stark difference in the prosecution of women or female and male returnees, at least in Germany and in many other countries, that has started relatively late. So in the case of Germany, female returnees were not really prosecuted systematically before 2018. Again, more details, I'm happy to speak about them if you're interested in that. So basically, so should women be considered members of a terrorist organization even if they did not participate in combat? And from 2018, the prosecution approach has focused on proving that yes, women can be members of a terrorist organization even if they have not participated in combat. So also a different approach than, let's say, in France, where there's much less evidence, where just to stay, for example, or the joining of a terrorist organization is enough. On the other hand, we see a lack of prosecution of male foreign terrorist fighters after 2019, either because they have died or because they are not returning anymore because they're detained or still abroad. So I think this is an aspect to keep in mind, that without the repatriation of male foreign fighters, they will not be prosecuted. And this is something that is quite clear if you look at the indictments of returnees in Germany. So just very quickly, the 2018 turning point, if you will, can be seen quite clearly. So where little female returnees have been charged for terrorist offenses before 2018, this goes down in the case of male returnees, and no further indictments have happened after like 2019 and 2020. And then finally, a quick look into the rehabilitation and integration of returnees. Again, a clear challenge for the years to come. So as I mentioned, due to the difficulty to get evidence, and this is also something that we heard already, there is a rather long period of pre-trial detention. The trials are rather complicated, especially because of this implication of international criminal law. So the actual prison sentence, so the regular detention, is quite short in the case of Germany, which means that overall there is limited time to actually work with a detained returnee on rehabilitation and then the post-release phase. So this is definitely a challenge. Then, as I mentioned, Germany with its federal system has different offers in place in each state. So we do not really use separate terrorism units, but there are different approaches to how to deal with the detained returnees in each state, and also the implication of which actors, which programs, and so on, and also different experiences. And it's not every state had the same amount of returnees, so some states might have much more experience, while other states had limited or no experience at all. Again, and this is related to the second point, there is quite an importance of civil society actors in Germany who are very important during the time, but also after prison. So they're providing different kinds of supports, like the social support, but also there's a growing awareness, as we have heard already, of the importance of trauma care, especially for minors, but also women. And then finally, with these many actors involved during the pre-trial detention, but also after release, because many people have to build their life again from scratch. So this is something that is, I think, a key necessity to ensure a multi-agency approach where both risks and needs of returnees are taken into consideration and people are aware of the different challenges that come with dealing with returnees. And there is, in some states, a special returnee coordination established since 2019 who are trying to coordinate the different actors. So I think this is also key. I think we've heard it from Abby the importance to have like one point of contact. So this is not only important, I think, in the case of minors, but also in general, to avoid confusion and to centralize the coordination of returnee cases in one point. So having said that, I would like to conclude with three key takeaways and three recommendations, if you will. So first of all, I think that it's rather limited what the decision, the verdict of the European Court of Human Rights has on the German approach to repatriation. I don't think it's going to really change many things. But what I would like to call on is to focus now on discussing how to repatriate male foreign terrorist fighters in order to ensure not only risk management, but also their prosecution, rehabilitation, as well as disengagement. So having a nuanced approach, an individualist approach to each case. And then again, ensuring long-term support is available for the rehabilitation, integration, and so also disengagement of all returnees, including minors. I think this is something that will be with us for times to come. And I think what we have not done enough in the past, travel and movements, for example, from and to Afghanistan, has been to take care of returnees and manage them and see how we can prevent recidivism, but also reintegrate those who are willing to do so. So I'm looking forward to your questions, and thank you for your attention.
Thank you very much. For people who do want to ask questions, again, you can either raise your hand and you can ask your own question, or you put them in the group and I will. I'm just going to take the chance to ask the first question here, which is, in a sense, this is our fault because we tagged it to the ECHR decision, so the discussion's been quite legalistic. But I was to kind of step outside there because obviously you're dealing here with a population of people who rejected all the laws of the states that had given them citizenship, and they in effect defected to another state authority and then declared war on the states that they'd been at home with. So in some sense, their claim to then be demanding legal right a little bit hollow. But beyond that, I basically wanted to ask the panel sort of substantively, either in principle or if they have specific, and how would you suggest amending the present approach? I mean, if in the sense of, do you just think that the key thing is to get them back as quickly as possible, or is there something else you would you think should be guiding us at the moment? If I can go first to Abigail. I think you're on mute. Can you hear us?
I think she just put in the chat she's having network problems, mate.
Oh goodness, no worries. Liam, if I go to you to hold it. Basically, how do you think the policy amended, the kind of immediate, the most immediate thing you would do to refocus us on what we're having?
Sorry, say the last bit again. I think your connection's a bit, it might be yours or mine. Say the
Oh,
last bit.
sorry. How would you kind of refocus policy, either in principle or in actual policy terms, to kind of get us to a better place?
I don't really know, but it seems that we've had like 2 or 3 decades of missed opportunities to do this, and like this is the problem I mentioned before of taking our eyes off this in between these flurries of activity in the global jihadist movement. Is like we had foreign fighters, returnees from various conflicts in the early 2000s. We had people traveling to other theaters in Somalia or Yemen throughout the 2000s, albeit in smaller numbers, and never really put in place anything to deal with this phenomenon. So now we're really stuck with the problem of the fact that, again, just the British example, 900 odds decided to join. I think like I was glad to hear about France's approach about people being immediately subject to potential charges for joining a terrorist organization, but unfortunately that's not the case in my own country, and hasn't been the case, where I think there's been, by the last count, this was on public record in 2018 or 2019, but there was over 400 who'd returned, and I think some 40 had faced any kind of charges, and not all of them were even related to their activity in the conflict zone. So, and then, an even smaller number of that faced actual lengthy sentences. So, I mean, even one of the British returnees who was on video with a bag of human heads, like sorting through a bag of decapitated human heads, got a 12-year sentence, and will, as we know, probably be out within 6 or 7 years. And I just don't think that's serious, for people who are, that's potential war crimes have been committed there, defiling the dignity of an enemy combatant, like all sorts of things have happened there, and we're giving people 12 years or maybe 3 or 4 years for joining a terrorist organization if we can pin that on them. So we're just in a really bad place with it, and that's what I meant with just being a bit more honest about the consequences of repatriation, and a bit more serious about it rather than obscuring it.
Thank you. Sharon.
Yes, hi. It's great to be after Liam because you trigger a lot of reflections. You made me think about something when you were speaking about committing the war crimes, and that you are happy that in France it's like this. So in France, I mean, if you are interested, there's a lot to read around this, but it's very repressive, the approach in France. Now, maybe there are good reasons, because we had quite important attacks here, as you know. But the thing is that this is something that for me is a little bit complicated, is that we prosecute merely on joining a terrorist organization and not about what they actually did there. So in this way, I think that the cases that we've seen in Germany or on war crimes committed, they are in a way a bit more interesting, because we actually look at the act that they did, and not a kind of a preventive criminalization against crime that might happen in France. So it's a very preemptive approach in France, a lot about what we can do, to prevent. But I would like to see more cases prosecuted about what they actually did. This could be, I think, more interesting. And like this, it is a little bit less, hypothetical, and then we can also think about rehabilitation, maybe more precise. Voilà. Thank you.
Thank you. If we
Carl, do you mind if I ask Sharon a quick question back on that?
Go for it.
Sorry, yeah. I've just been robbing all the time because I need to go fairly soon, but yeah, I totally agree with you that it would be better to see people prosecuted for their actual crimes where there's evidence of it, for sure. But interested in the way that you said that it was like preventative for like hypothetical that might happen in the future. I mean, is it, when you put it in the terms that Kyle put it in his original question, that people have turned their back on these democracies and gone and joined a group which is officially at war with them, and committing all sorts of crimes, not just against Yazidis, but the civilians in Syria and Iraq living under a really repressive state apparatus. Is that, like, for me, that should be enough for some sort of sanction against the people who join that group. Not just. I agree, there is an element of prevention to it. The potential threat of returnees, not just in terms of launching attacks, but in radicalizing others. But just, for me, the act itself is deserving of some kind of sanction.
Yeah, no, I mean, this, anyway, when we are speaking about the conflict itself, so France was also targeted, she made some targeted killing, right? And they were, because I think that we need to divide a little bit also the category of groups of people, because it's not all the same, so there were the moment that you have actual combat, right? And then, France didn't try too much to arrest them, and under ECHR they could also target and fight, and this is what they did when they were with the coalition fighting there, and So this was the regime under ECHR, which was okay. Then when we looked at, because here we have hundreds of persecution in France. So when you go to see in court those people, so of course you have the one who were really combatant. And when you are combatant, okay, you have a certain degree of reading and a certain amount of punishment. But then you have a lot of people that, you know, wanted to go and then they change their mind and come back. Okay, there are all kind of, you know, of biography of the people. And this is interesting because in court we can listen to them and understand why they joined and what happened. And at the end of the day, these are French people, right? And also, so I think that we should think why French choose to do this, you know. And in the Bataclan trial, it was really interesting because you could see the group of people that were attacking the same age of people like them, right? So a question is why French or Belgium that are 20, 30 years old will go and attack the Bataclan instead of going there and listen to the music with them, which they could theoretically, yes. None of them were so, you know, Islamist that they won't listen to music. So yeah, so there's a lot of gray there. And I think courtroom is an interesting place because you can really hear the story and see. Then the decision how far you want to repress or how far you also want to open the door to rehabilitation, this is now the work that has been done in France. Because, okay, you put them now all in prison for 10, 15 years, but a work needs to be done in prison. Otherwise, it's a bit useless.
Thank you.
If I
we
can...
go to... Oh, sorry.
Yes, if I can jump right in, because that's a point that I would like to make. I think that if we speak about the length of sentencing, I think it's important to consider that you can have a sentence of, let's say, 20 to 30 years, but if there is no proper offer for that person to rehabilitate, or there are even measures that push that person to further radicalize, then that's even more problematic than giving that person only a short sentence. So I think that we should focus more on the quality of the prison sentence. So and I think that's one of the issues with the French approach, is that there have been so many convictions and so long prison sentences on a prison system that is already overloaded. So the question is, can these people even be rehabilitated if they want to? Or will people have the chance to reflect on that in these conditions? So I think it's not about having the longest sentence possible, but the quality of the sentence and how we deal with these with the detainee in the prison and post-release. So I think that's one aspect to keep in mind. And about the accountability, I think at least in the German case and also in France, even more so, the mere fact of having gone and having been over there and having been affiliated in some sort with IS, another terrorist organization, that's already like the first indication to have a criminal investigation against you. But then I do think that it's very, very important to not have a sentence just based on this affiliation, but to really in a trial discuss what has pushed this person to do what they did, and to provide an exact account of the crimes that they may have committed. Because if you have a victim, and that includes, of course, members of the Yazidi community, but also their own children, maybe. If the conviction is merely done on this affiliation and no concrete cases of crimes are discussed, then that can be very frustrating. So I do think that we need this kind of discussion in the courtroom to really see what is the evidence, what has been committed, because there is still this kind of innocence until proven guilty. And I think that's very important to not overturn our rule of law system because of terrorism offenses. And for example, in the case of Germany and in the case of prosecuting female returnees, they had the same problem, because in the first place they thought they are all only over there, they cook and they have children, that's it. And then because they were forced to look for something else. They found something else. And now these are the cases that also in the media are discussed on what women have done over there, what kind of role they were playing, what kind of responsibility they have, and what this means for risk assessment and rehabilitation. So I do think that focusing on these cases and how they can be charged for precise crimes is actually a very, very important condition then for what comes after the conviction.
Thank you. We go to Phil for his question.
Okay. Thanks, Kyle. I'm not sure how well you can hear me. I'm in the middle of nowhere, Canada, but my cottage for a bit. So the good, great, thank you. Great panel. Thanks for the invitation. My perspective is obviously, I think, unique. I spent 32 years in security intelligence in Canada with the Canadian Security Intelligence Service. I've written books on foreign fighters, on terrorism, so I'm not a legal scholar. I have no intention of responding to the ECHR legal perspective. But just a couple of points I want to put to the panel. If these people are repatriated, they are going to become first and foremost the responsibility of law enforcement and security intelligence to monitor them, to investigate them, to see what threat, if any, they pose to our societies. And I can tell you that these security services and law enforcement are already overburdened with other cases. So, I mean, it may sound trite, but if they're over there, you don't have to worry about them right now. I mean, it's not a great answer, but it's one point. The other thing I'm curious, what hasn't been raised so far, and I've been talking about this for years now, why haven't we spent the money to establish in situ courts and judicial systems over there? Liam raised a really good point about evidence. The witnesses are there. They're not in Canada, they're not in Germany, they're not in France, they're not in England, they're there. Why have we not spent the money and time to establish legitimate, fair courts in Iraq and Syria, perhaps under Kurdish administration, to try these people where the witnesses are readily available, the victims have a right to see justice being done, and if necessary, they can serve their sentences where their crimes were committed. I mean, isn't there an international, I don't know, practice of having people serve their crimes or serve their sentences where their crimes were committed? I mean, if as a Canadian, I go to Singapore and sell drugs and the Singaporeans pick me up, they're going to try me in Singapore and I'll do time in a Singaporean prison. Perhaps if Canada has extradition with Singapore, they can send me back home. But I'm really curious as to why we haven't discussed that. And furthermore, on the kids, and I think Sophia mentioned this in a comment, so thank you, Sophia. To me, any parent who brought their child to ISIS, knowing exactly what ISIS was all about, fits the definition of an unfit parent, at least under Canadian law. Again, I'm not a lawyer. And these children, they're the victims as well. They're the victims of their parents. And why we're not taking the kids from their parents who are terrorists and putting them either with extended family, which is the best, I think, solution, or a worst case scenario where there is no extended family under wards of the state. I'm not sure why that hasn't been discussed as either. But anyhow, I think you've all raised good points. It's a very complicated issue. I think Liam's mentioned, or perhaps Kyle, this is not easy. And I think a lot of the argumentation I've heard here in Canada and abroad is, well, just do this or just do that. And it really isn't as easy as that. So thanks, Kyle, and thanks for the EER for establishing this panel. And kudos to you guys for continuing the conversation, because this is not going away. My country has not repatriated. And at the same time, we've not yet charged anyone who has come home with being a member of ISIS. Not a single person. The only case we have is the famous hoax case of Khalifa al-Kennedy, who hoodwinked Rukmini Kalamaki of the New York Times into thinking he was an ISIS member, and in fact, he never even got near the place. So anyhow, I'll end there, but thanks very much, Kyle.
Can I jump in relation to what you said? So, the idea of a local tribunal or internationalized tribunal that will be there, I think it's a very good idea. I saw even here when we prosecuted for the Bataclan trial, during 1 year, we had this case last year, and now all the accused are going, not all, but half of the accused are in Belgium, the same accused for another attack that they did there in the airport of Brussels. So, and I would even thinking, now I understand why in France wanted to prosecute the Bataclan here in France and why they want to prosecute in Brussels. But, it could make more sense to have one court dealing with different cases. So it could be also a way to say, you committed the crime here, let's do the prosecution there. Okay, so what are the problems? Why, or maybe why it's not happening? So there are two things. Usually when you create a court, so of course he has jurisdiction, a territorial jurisdiction. So whoever committed crime is under the auspice of this court. And then there is the question whether there were also crime committed by the Allies forces, for example. And then maybe this is one of the reasons that some state will not, I mean, you know, the Nuremberg style courts, they don't really operate anymore, that only the victory side will do a court. So the question whether or not we want to establish a court in Iraq or in Syria could imply also maybe prosecuting whoever committed crime on this area. This is one thing. And the second thing is, but I still think it's a good idea. This is the good idea, because people should be also accountable to the victim which are on the place, right? And then the victim have access to see what is going on, and they feel that justice is being done, because I'm not sure how far the victim in Syria feel that justice is being done when they're jailed in France for terrorism. So I think it's a good way. Then another issue is how to establish this and who will finance this, and etc. So it should be a bilateral agreement, I imagine. Of course, with Syria, not possible. Kurdish state is not a state that you could decide to do there. I mean, you know, they are not an autonomous. I mean, this would be impossible to do. And then to do it in Iraq, so, you know, they tried to do it through the Iraqi government, but of course the court in Iraq are not, but then you will need to see how you establish this, yeah. Well.
Thank you. Do you want to go to Abigail?
Yes, I hope my network is okay for now. I'll kind of just jump off a little bit back of what Sharon was just talking about there in terms of the option of creating establishment within the zone. And I think that discussion's, yeah, there's a little bit more nuance to it, in the sense that there are actually a lot of difficulties with that particular solution, in the sense that if we look at legislation alone, the area in question is very much used to different practices and different penalties for certain crimes. So, I mean, the most notable one would be death penalty, which raises particularly issues for European countries who have signed the European Convention of Human Rights, as obviously there's certain issues legally whereby if they would allow for a national to be sentenced to the death penalty, that could trigger some of their obligations under the convention. So it becomes a little bit more complicated than just, yes, let's fund a court and let's create it and that kind of thing. And I think one of the other issues to consider as well is, if it's already taken a while for them to begin repatriation, where would the funding come from? Why would states realistically want to put funding into this? I'm pretty sure I've looked into this before, in the sense that there has been discussions before and states haven't wanted to put the funding into it. They've just said, just deal with them for us. So it becomes a little bit more tricky than just let's go and do it. And I'm trying to remember, I think there was one also point about unfit parents, which actually we can also look directly to the Convention on the Rights of the Child. Article 9 discusses separating a child from the parent, but that situation itself is subject to various different discussions and decisions from various bodies, and can't exactly remember from the top of my head, but there's a lot more of a legal process that goes to separating a child from their parent. And one of the main principles there is the best interest of the child. So at least when we're looking at repatriation, children and women right now, that is something that is at the forefront of a lot of discussions, is what is in the best interest of the child. Is it to separate them from their parents, or is it not? And even if we look demographically at the children who are in the camps, many of them are under 10 years old, and many of them were actually born in the camps or born in Syria. They are obviously subject to various different things compared to a child who, for example, was of an older age and then participated in various terrorist activities whilst over there. So a couple of things to consider when looking at these things, but for myself, I believe that, yeah, the best interest of the child is at the forefront, and that needs to be considered when deciding whether to separate or not.
Can I ask a slightly technical question, which is, when talking about constituting a tribunal here, especially under the so-called Syrian Kurds, we are talking about a terrorist organization itself. The PKK, which is the entity that actually runs what we agree to call the SDF. How would that even work? How would we, I mean, we would have to finance that, which, I mean, I guess we've already done, and we circumvent our own laws by the SDF means. Would we just carry on doing that? Would the European courts agree to recognize a court under the jurisdiction of the PKK?
I think that's a really good question, but a difficult one, in the sense that, at least the way I interpret it, is that it was more generally, could we create a court somewhere in Syria and Iraq? I don't think it was mentioned specifically who would actually be controlling that.
Right.
But yeah, for myself, I don't have too much knowledge in that specific area. Obviously, if we've looked at previous tribunals and stuff, there's a very different background to those situations. I think someone mentioned Rwanda. I mean, also Lebanon. There's various different courts that have been created, but that is under the auspices of the United Nations. Very different from where we're looking at right now.
I guess on the
you know, court can be established through different agreements. So there are different forms to create. It's not necessarily through the UN. For example, when you have in Senegal the prosecution of Hissène Habré, which was a hybrid court, it was created in Senegal. It was through the African Union. So the thing with courts is that you can invent whatever you are. You just need people to agree on this, right? So I think that when we speak about the court to be there, the idea is to have some kind of international court, because of course we don't want the Iraqi or the Kurdish to apply their own law on the cases. This is the idea of making an international court, so we can have also equal prosecution everywhere. So whatever you did, it will be the same sentences, the same evidence, the same rule of law thing. So the idea, it could be, for example, if we think to do it in Iraq, that you do a kind of agreement, so between European Union, Iraq, the US, Canada, I don't know, whoever is interested in running this, then they put money to create this court, and then it's a hybrid court, you know, so you define the crime, and more or less you don't invent anything, because war crimes, crimes against humanity, they already exist, those crimes, right? And we have in the UN in Geneva, we had now this IIIM that are collecting evidence, and they're doing in view of maybe one day having this kind of court. So when there is a political will, we have many possibilities, based on previous try that we had.
Sure. Sorry, I may have slightly confused the issue with it. I was talking about a very technical issue, which is this court, however it was constituted, would have to be executed by some local actor. And in the case of the Kurds, the Syrian Kurds so-called, you're talking about an entity that's already designated as a terrorist organization. Obviously, the Syrian government is an outlaw regime, and Iraq's government is very heavily under the influence of Iran, which is a notorious state sponsor of terrorism. So I guess I'm just confused about how that would work in a technical way. But if we go over to Sophia, because she hasn't been in for a long while.
Yeah, thanks for bringing me in again. I think that on the tribunal question, I would just like to add that there is indeed the problem of who will be prosecuted by the court. And there is, I think it's problematic to only focus on, let's say, foreign terrorist fighters associated with Daesh. So what about crimes committed by, European military over there, or what about Assad's regime crimes? So I think it's important to see the complexity of the issue. Second aspect is indeed funding. So who would be willing to finance such an endeavor, which would also take a long time. And I think the discussion has been, going on for several years now. There does not seem to be much progress. And from my opinion, there is not much political willingness to actually bring something like that in action. Maybe it's coming up again, but for now, I don't feel that it's a viable solution at the moment. And then finally, and I think that's the point you're raising here, is that, okay, so we convict people in that court, however that will work, and then what? Like, where will they serve their sentences? So they will have to be repatriated to serve their sentences in their state, in their countries, and so on. So I think that there is a lot more complexity to it from legal, but also logistical and financial perspectives. On the aspect of the child endangerment, I do think that it's a very complex issue, and I do think that the first impulse might be to say they have no longer rights to their children, but that's not how it is. And there is also a separation between, as Abby said, the best interest of the child, which can in some cases be to leave the child with the parent, and ideology. And in some cases, someone can be radicalized, but still be a good parent. So I think there's like important to differentiate between terrorism offenses committed or violence committed against the children, and whether someone is fit to be a parent. And there are certain courts deciding on these issues. So it's not a criminal court who decides this person is a terrorist and thus she or he is no longer fit to be a parent. So these are different aspects. And I do believe that there's a lot of effort put in what is the best interest of the child, and really seeing the separation from the parents as a last resort. So I do think that it's a complex issue, and it's not as easy to say they have gone there, so they're no longer fit as a parent. And also, I mean, maybe last point, people can change, right? So like, you can be unfit as a parent in some moment and like regain the possibility to be fit as a parent later on, as least as I understand.
Thank you. We have gone for quite a while, so I'm afraid we're going to have to bring this round to a close. If I can go once more around the panel, basically just for any closing remarks, thoughts. If I go first to Abigail.
I mean, not really too much. I think it's been productive in the sense that, yeah, with the decision at the court, it'll be interesting to see what happens next. I think this issue is a lot more nuanced than just should we repatriate or should we not. There's a lot more to consider in terms of how it will be done, how do we rehabilitate, reintegrate. Of course, as soon as children get involved, even more issues start to come up. So yeah, I'm interested to see where it goes. I hope that some more solutions will be found. But the decision itself, maybe not the most groundbreaking piece of legislation that's come forth.
Thank you very much. Sharon.
Yeah, I completely agree with Abby, what she said. Yeah, I mean, I don't have any concluding thought. It was an interesting discussion, and thank you for all those reflections.
Wonderful. Sophia?
Yeah, maybe I think my last thought is always that it helps to have nuance also in terms of cases. So I do think that it helps to, let's say, view women not only as victims or only as monsters, but to consider all the possible roles and profiles that they can have. And the same holds true for men, and even for children who have grown up during ISIS and are now, for example, adults and are treated as adults. So I do think that in the sense of what are potential risks, what are needs, what are challenges that lie ahead, and that's, I think, something that has been made in the sense of there is not enough research still on how they went into what they did and what would help to bring them out of it again. So I do think that bringing in this kind of nuance and profiles does help to also prioritize resources. So if we speak from a security perspective, not all returnee has the same profile and needs the same kind of surveillance. Not everybody needs the same kind of 30-year sentence and the full force of the criminal justice system. So I think if we look at it from an individual's perspective, that I think would help in tailoring our responses to the issue.
Thank you very much. Thank you to all of the panelists. It was great to have you here. Thanks to the audience, and we'll see you again soon. Bye-bye.